Hello, my name is Dennis O'Brien. I chair the Policy Committee at Space Renaissance International, a COPOIS permanent observer. Today I'm going to talk about the legal aspects of outer space settlers and settlements. We consider both terms in their broadest meaning. A settler is anyone who spends any time in orbital space or beyond. A settlement is any location where one or more persons is living. With these definitions, we have found that there are four general areas of study. One, the current framework of national and international law. Two, human rights and the right to development. Three, self-governance and autonomy. Four, independence. The Outer Space Treaty of 1967 is the foundation of space law. There are several articles that affect settlers and settlements, including Article 1, which guarantees free access, Article 2, which prohibits appropriation, Article 4, which prohibits military bases and installations, Article 6, which requires authorization and supervision of all national activities, Articles 8 and 12, which extend a country's jurisdiction and control, and Article 9, which protects against harmful interference. Article 6 establishes the interactive framework of national and international law. Every member state or intergovernmental organization like the ESA must authorize and supervise the outer space activities of its nationals, including all non-governmental entities. Thus, any early settlers and settlements will be operating under the laws of the country or organization that authorizes and supervises their activities. If more than one country or organization is involved, there will need to be an operating agreement between them, as with the International Space Station. Because Article 2's ban on appropriation, neither countries nor their nationals can claim outright ownership of any location in outer space, though their jurisdiction and control will extend over objects, stations, and facilities under Articles 8 and 12. In addition, Article 9 prohibits harmful interference, so there will be a de facto right of non-interference for any occupied location. COPOIS is currently considering the adoption of a principle that removing a resource from in place is not inherently appropriation, even if it is regolith that is removed from the surface to build a lunar shelter or facility. Thus, buildings will be owned and marketable, even if the location is not, and will be protected from interference. In addition to the Outer Space Treaty, there are two international declarations that are relevant to outer space settlers and settlements: the Universal Declaration of Human Rights of 1948 and the Declaration of the Right to Development of 1986. The UDHR has two provisions of interest. Article 14 states that everyone has the right to seek and to enjoy in other countries asylum from persecution. Article 17 states that everyone has the right to own property alone as well as in association with others. It is important to acknowledge the right of asylum, as OST Article 8 states that a state party shall retain jurisdiction and control over any of their personnel. Most spacefaring countries have already signed the Refugee Convention of 1951 or the Protocols of 1967, with India and many Middle East countries notable exceptions. Although the ban on appropriation in OST Article 2 does not explicitly mention private entities, Article 6 requires countries to assure that activities of their nationals conform with the treaty. But we should nevertheless acknowledge that individual settlers will have the same property rights that are available to any country. For example, ownership of resources removed from in place, and ownership of the right of non-interference, which will protect locations in use. Outright ownership of land will probably need to wait until a settlement becomes independent, at which time it must be made available to individuals. In the Declaration of the Right to Development, Article 1 states that the right to development as an inalienable human right. Every human person and all peoples are entitled to participate in, contribute to, and enjoy economic, social, cultural, and political development in which all human rights and fundamental freedoms can be fully realized. It also implies the full realization of the right of peoples to self-determination, which includes the exercise of their inalienable right to full sovereignty over their natural wealth and resources. Although these declarations are not binding, they have established principles that have guided both national and international law for decades. We must take them with us as we leave the home planet. Some in the private sector are already planning the details of settlement self-governance. The efforts of SpaceX are perhaps the most ambitious. Its Starlink Terms and Services Agreement states that the parties recognize Mars as a free planet and that no Earth-based government has authority or sovereignty over Martian activities. However, this clause directly contradicts OST Article 6 and would not be enforceable. A clearer path to autonomy is the development of self-governance as the need and opportunities arise. Although almost every minute of activity on the ISS is controlled by Earth-based authorities, a time will come when settlers want to decide their own schedules and how they will work and live with each other. Such devolution of governance is common on Earth. Many countries have federal systems with political subdivisions such as states and territories who are responsible for most functions other than foreign policy and defense. Until a settlement is ready to become independent, seeking autonomy within the legal framework of the authorizing and supervising country or organization is the only legal path available for the development of self-governance. Those who support self-governing settlements should promote national laws that facilitate such growth. So what will it take to become independent? A settlement will at least need to meet the 4 standards established by the Montevideo Convention, which has been widely accepted as customary international law. 1. A permanent population. 2. A defined territory. 3. A government. And 4. The capacity to enter into relations with other states. Although Article 3 of the Convention states that the political existence of the state is independent of recognition by other states, such recognition is important as a practical matter. Any new sovereign state will not be bound by the Outer Space Treaty and will be able to claim territory. It could then offer to adopt the OST and be subject to customary international law in return for other countries recognizing its claims. Note that the prohibition against appropriation in OST Article 2 actually favors independent settlements. It keeps the current world powers from claiming land while preserving it for future settlements. On behalf of future settlers, we hereby declare their intention to seek independence and call upon the state members of COPUOS to do nothing at this time, politically, economically, or environmentally, that would interfere with their future interests. It is not too early to consider the legal aspects of outer space settlers and settlements. This paper is just the beginning. Space Renaissance International speaks for the settlers. We must start now to protect their rights and to chart a path to self-rule and independence. They are counting on us. In many ways, we are the settlers. Let us find a way to move forward without compromising their future interests. For more information, please visit our website, spacerenaissance.space. Please also visit SRI's side event on our proposed 18th Sustainable Development Goal, Civilian Development of Space. Thank you very much for your time and attention.